Hello, this is IP Stories by 4IP Council, the podcast about innovation and intellectual property. Join us and you will hear about the journeys through invention, creation, and IP understanding of our guests.
I'm Pınar.
And I am Axel. And we have with us today Professor Tilman Müller-Stoy, Unified Patent Court, or UPC, representative and partner at Bardehle Pagenberg. Hello, Tilman. Thanks so much for joining us today.
Hi, everyone. Thank you for having me.
Thank you so much, Tilman. I'd like to begin with your journey. And I'd like to ask, what first drew you into the world of IP law? And did you always know that you wanted to be a patent litigator?
So the answer to the second part of the question is not at all. It was a complete coincidence. Actually, I did an internship in 1999 in my firm where I still am, so I never had a reason to leave. And then only through this internship discovered IP law and patent law. I liked it, so I kept moving in that space.
Wow, 26 years in the same firm? That's amazing. I suppose that's quite rare.
It is quite rare these days. I'm a very loyal person, also towards my family, my wife, so maybe that's why.
Good to know. But so you have handled many patent disputes. I mean, we can find your name all over the internet, and for more than 2 decades now. Was there a turning point or landmark case early on that shaped your approach to litigation?
I wouldn't say that there was a landmark case or a turning point specifically. I think it was an evolvement over time, maybe even a gradual one. What I would note, though, is when I started in 1999 and then later as a full-fledged attorney, patent litigation was still more national than international. And that really changed. Patent litigation got much more complex, much more international. The cases got huge. So you really needed large teams, very clear responsibilities, and good project management. And that's what really changed my practice over time.
Okay. But were you working the same manner, or did you see changes in this industry?
I saw changes in various industries. Maybe the most notable ones, standard essential patents. They didn't play a huge role, some role, but not a huge role when I started out. And then maybe in the early 2000s, we got more and more of those SEP cases, which were, of course, international in nature because it was global portfolio licensing. And that required also some antitrust knowledge. And that needed to be collected, so to say, and used.
And since we're talking about the evolution of patent litigation, how would you describe this landscape over the past years, from the national fragmentation we had and now with Unified Patent Court? And if you could explain for our listeners a bit what Unified Patent Court is before jumping into the question.
Yes, happy to do that. So the Unified Patent Court, although it is only in operation since a bit more than 2 years, is a long-term project. One can really say that. I believe as early as the 1970s, the first attempts were made to create a common court for Europe to litigate patents in one court, infringement as well as validity. There were several attempts. And only very recently, the European Union achieved to make it happen, together, of course, with the member states of the UPC agreement, which currently are 18, initially 17, and then Romania joined 18. So the UPC, the Unified Patent Court, is what I would call a one-stop shop for litigating European patents. That means classic European bundle patents, as well as the new kid on the block, which is the unitary patent, so the European patent with unitary effect, in one court in a centralized procedure with its own procedural law and its own substantive law, which allows you to get relief, for example, an injunction for those 18 member states, and based on a recent Court of Justice of the European Union decision, BSH versus Electrolux, even for EP member states which are not a part of the UPC, like the UK, for example, or Switzerland or Turkey.
That's amazing.
Wow.
So what you just explained is it is a 50 years project that just started 2 years ago.
Correct.
Wow. Okay.
That's such a long journey, and we're finally there.
Maybe to address your question, Pina, how does the court look like today, so to say? It really is a game changer for European and, in fact, global patent litigation. It has a global impact. We are seeing a clear trend towards the European case being first. It used to be the US case first, but the real pilot case seems to be now the European case, because you can get through the UPC meaningful relief within about a year of litigation at relatively reasonable cost, with, in the meantime, a good level of predictability. And testament to that is that we've seen a number of global settlements happening right after UPC litigation was filed or decided in first instance.
That's very interesting. So it shows that it really has impact, positive impact, and it is really changing the way businesses are maybe leading disputes. But just earlier you talked about injunctions, and I believe that you recently won the first inter partes preliminary injunction under the unitary patent. So I'm not sure that everybody knows what an injunction is, but can you just walk us through the significance of that case and what it signals for the UPC moving forward?
Yeah. So recently is a bit of a stretch, I would say, because that happened very early, so to say. We filed the case on the first day, the 1st of June 2023, and we got a decision on the 20th of September 2023, which was an inter partes preliminary injunction, which was granted for my client. Now, what is an injunction? An injunction is basically a cease and desist order. It's an order by the court with which you can stop the infringer on the market relating to the infringing activities attacked. And that meant, in the case of this unitary patent, that we could stop the infringer in 17 jurisdictions based on one preliminary injunction granted for my client. We have seen since then quite an involvement of what I would call the UPC's PI, preliminary injunction practice. We've seen a few cases where even ex parte preliminary injunctions were granted by the court, but those are quite limited, say, to trade show scenarios. And we've seen a much larger fraction of PIs being granted inter partes based on classic bundle patents as well as unitary patents. So, for example, I just won another one last week in the Munich local division in a medical devices case, where, interestingly, the injunction was ordered at the end of the oral hearing. So no delay at all, on the same day, so to say. What I think is of general importance to understand for patent owners as well as potential defendants, that the PI practice at the UPC is relevant. It does exist. We see a relatively high success rate, which is in the 50% or so. And that means that it can be a great benefit to patent owners with an urgent need to stop an infringer on the market. And it can be a high risk for potential defendants, especially when they launch products on the market or just enter the market. So the PI practice of the UPC is quite relevant. It is probably the most promising PI forum on a global scale, one has to say. And that's why relatively many cases have been filed and will continue to be filed. There's one defensive measure which is important to know, and that's a so-called protective brief or protective letter, which is basically a written submission a defendant who expects to be sued with a PI can submit with the court as a preemptive measure. So it would say, dear court, in the event that patent owner XYZ attacks me with a PI request, here are my defense arguments. The patent is not infringed because the patent is not valid, because the case is not urgent, because, and so on and so forth. Those protective letters come from the German tradition. They are kept in the custody of the court and are only served on the patent owner once the patent owner actually files a PI case, and until then remain submarine written submissions. So it can be a very important tool for the defendant to try to proactively defend. There is one important aspect which I would like to mention, and then I can pause there. And that is that protective letters are not a good strategic tool if the arguments are weak. Because if the arguments are weak, that can give the court even more comfort to grant a PI, which means, in essence, one has to make a strategic decision whether or not to file a protective letter and with which arguments.
That's a great recommendation. I suppose people will be listening very carefully.
Yeah, I bet listeners are taking notes at this point. So, given your front row seat at UPC's early years, what practical lessons have you drawn from this operation, both procedurally and strategically for clients? Well, you already started getting into them a bit, but if you have anything else to add.
Yeah, happy to. Let's maybe start with one very important notion, and that is what I would call think UPC. And that's not a slogan that I invented. It's actually a slogan that President Grabinski of the Court of Appeal invented and told the judges to apply. And that means the UPC will make its own thing. It will create its own case law regarding procedural as well as substantive aspects. It will, of course, consider prior national practice and case law as a source of inspiration, but it won't stop there. It will try to do the best mix, so to say, of what has been there and what can still be developed in terms of law. And the overriding idea is to harmonize European patent law, even together with the European Patent Office. And we've seen a number of respective decisions coming out of the Court of Appeal and the first instance in that regard. So that's maybe the most important notion. Do not anticipate that a case will be decided like a German judge would decide it, or a French judge would decide it, or an Italian judge would decide it. The UPC judges think UPC and make their own thing. Another important aspect is that by now, that means after a bit more than 2 years of operation of the court, we have a pretty good level of predictability, and not all, but many important legal questions have been resolved. To start off, the procedural law has been fought through in many cases, many sideshows, many procedural appeals, and that is pretty much settled, I would say, now after 2 years. So there you have decent predictability and quality, of course. But even when it comes to the substantive law, many important questions have been clarified. How to do claim construction, how to assess inventive step, how to look at the doctrine of equivalence. At least some initial cases have been decided there. How to approach friends in SEP cases. Some initial cases have been decided there. So all in all, I would say that the court had a huge cadence in the first 2 years. Just a few days ago, case number 1000 and 1001 were filed with the court. And that means that we already have a decent body of case law with which we can operate. So I have no idea what's going to happen days are clearly over, and that gives clients even more comfort to use the system.
More than 1,000 cases filed in less than 2 years. One thing that is reassuring that you just said is there is some sort of predictability, some certainty, and I suppose it helps everybody to feel more comfortable with using the UPC. But although I suppose that not everybody is very, reassured. And what's, in your opinion, what are your clients or some clients, what are the clients most concerned about or excited by when it comes to navigating this new forum?
I would say that the excitement is clearly on the plaintiff side and the concern is on the defendant side. For the reasons I mentioned earlier, in particular, the possibility of a pan-European injunction which could stop a business all over Europe, basically. So it's a high risk for defendants. Also, the deadlines are very short to respond to a litigation campaign, which means that defendants are very well advised to have their ducks in place. That means have their counsel ready, anticipate cases, prepare prior art searches, and all you can do for the event that you will be sued, because once you are sued, time is of the essence, and it can be very challenging to defend a case. The excitement on the patent owner side, besides that pan-European injunction, is clearly the speed of the system. You get a decision within about a year in main proceedings, and a PI you could get within days in case of ex parte PIs, or within 3 to 4 months in inter partes PIs. The costs are quite reasonable, larger than maybe in an individual European country, but much cheaper than the US or UK patent litigation. The predictability and the certainty is good, both with regards to the process as well as with regards to the substantive law. So I would say, having seen many courts operate globally, that this would be my favorite, the best patent court I'm aware of on a global scale, which makes patent owners very excited because they can make better use of their patents at a more reasonable price compared to litigating country by country by country by country.
Well, that's great to hear.
Maybe just one further point, and that is a concern that several users have, as well as several countries have, some judges have, some lawyers have. The question is it really a unified patent court? In the first 2 years, most of the cases were filed with the German local divisions, which are in Munich, Düsseldorf, Mannheim, Hamburg, in that order, also in the number of cases. We then have the local division The Hague, the local division Paris, to some extent the local division Milan, and the central divisions also getting cases. And then a few cases, so to say, spread out over the other local divisions and regional division in other countries. But from a policy perspective, it is not ideal that the court is currently being considered to be, Germany plus. And that's something that needs to change, especially when the transitional period is over. There needs to be the political will to continue the system, which in itself is a success, but also politically must be a success, so that I believe that users are well advised to help shape it as a unified European patent court and try to get rid a bit of the German emphasis, which is, of course, great for my business. But thinking more broadly, I think that's an important point.
Yeah, well, that's such a great point. And UPC is just one piece of a much bigger puzzle for your practice, right? You are often the European lead counsel in multinational disputes. And how do you approach building cohesive legal strategies across jurisdictions with different legal cultures and procedural rules?
Yeah, that's a very good question. And I would have very lengthy answers to that, but let me try to keep it short. I think two important factors are clear coordination and responsibilities, as well as proper project management. So someone needs to be in the lead and needs to be accountable. And so to say, be the shepherd taking care of the herd. Now, it's very difficult to, explain a common approach because each and every matter is somehow individual and needs tailored strategies. But there is one common characteristic, I would say, and that is that the client has a problem and that the international team has to help solve it. And that regardless of the size of the issue. Many factors, I think, are relevant, and different clients and team members have different priorities, which can eventually change over time. So I think the biggest challenge, especially in a coordinating role that I often have, is to continuously identify and understand the client's business objectives. The question is how to do that. And the simple but important answer is ask questions, even the stupid ones, and listen. Because as a trusted advisor, you need to take accountability and challenge opinions, be it the opinions of the clients, be it the opinions of other team members, be it the opinions of your own team or yourself. It's better to take some heat than to act as an echo chamber, because as an echo chamber, you cannot add any value.
That's a very, very good advice. Listening is very important. And it leads me to one interesting question that we receive many often from startups and SMEs at 4IP Council, because we provide a lot of how-to guides, but many startups are saying in Europe we are encouraged to file patents. We are helped by financial help from the European Commission, from member states. But once our patents are filed, the issue is how can we enforce our rights? Because there is no assistance. And many times we heard this and we said, thanks to the UPC, it might make things easier for you. Do you see an increase in the number of startups and SMEs using the UPC to enforce their rights?
That's a very good question and a really interesting development. Before the system started, my personal opinion was, and that proved to be wrong, by the way, I thought this is a system for the big guys with the deep pockets, high value cases, high cost risk, cost reimbursement up to 2 million per case. This is not a place for SMEs. That was my anticipation. And that was, by the way, also critic that was mentioned by several actors in the market over years, and was a foundational point, so to say, in that 50 years evolvement to the court. Now, what we have seen in the first 2 years is that, in fact, SMEs are using the court as plaintiffs. Of course, on the receiving end, they can choose. They're being sued. But there is a surprisingly high number of SMEs who has started using the court in smaller cases, but those are being decided with the same quality and the same speed. And I must say I changed my opinion. And given those facts that we've seen, I expect the court to also work for SMEs. Would it work for startups? That's really a question mark. That would require some sort of litigation funding, because usually startups cannot afford the UPC. But let me give you one example, which is quite interesting. I defended Kinexon in a case which related to the connected ball technology of the Euro Championship of last year against a PI request by a Dutch company. And we won. And Kinexon was happy with the result. And Kinexon is in the transition between a startup and an international SME, so to say. So they were the defendant in that case, but they were happy with the result and happy how all of this played out. Of course, we won. I mean, that's then nice. But I didn't hear them say, "Oh my goodness, we cannot afford this. We're being blackmailed," or anything of that kind.
That's great news. I'm glad to hear that. And finally, I mean, that's maybe one of the most difficult questions, but what advice will you give to young IP lawyers or even innovators looking to navigate this increasingly complex and global IP environment?
Yeah, let me focus on the young lawyers because the innovators should innovate and then create patents and do something with their patents. And that will be possible also going forward and will be very important in our European knowledge society. But looking at young lawyers and patent attorneys, I would have two sets of advices. Let's maybe start with a key concern, which is AI. I would say don't be afraid of AI. Use AI as a tool in a litigator's toolbox. It cannot replace a litigator because as a litigator, you also need strategic advice, personal accountability. You need to partner with the client. And these things cannot be replaced by AI. So AI shouldn't be a concern. It should rather be a tool. And the focus of the work will then be oral argument, focus on strategy, clear advice, clear direction to the client. So own the case and partner as a trusted advisor with your client. That's the first set of comments I would have. The other set is, and that's very general and would probably also apply to other professions than patent litigators, but likewise important. That's how I looked at it when I started. Be hungry and aware. Take your time, step by step, and don't hurry. It's going to be good in the end if you just let your passion flow. And there are opportunities everywhere, and the trick is to pick them up, but also to let some go because you can't have them all. So be selective and creative.
Thank you so much for sharing your knowledge, sharing also how the UPC has been helping. And I think that's very positive. It gives a bright future on how to use the UPC. So I would like to thank you very much again. And Pinar, do you have any last point or everything good?
I think we're all good. Thank you so much for joining us today, Tilman.
Thank you, Pinar. Thank you, Axel, for having me. It was a pleasure.
Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.